by myself. He and I used to work together on this out of 7 days.
Is ever a mistake in a TV guide? I think I died.
The bandit is back. Now, before you go getting all worked up about it, let me reassure you people there ain't no way he's gonna make a fool out of Buford T. Justice.
Burt Reynolds, Sally Field, and Jackie Gleason. It's Smokey and the Bandit 2. The Bandit is back, and you can catch him 9 p.m. Sunday.
BCTV, we're giving it all we got. BCTV, we're giving it all we got.
Good morning. If ever British Columbia needed an ombudsman, it is now, as we're faced with this bunch of bills which may well change the face of British Columbia. But speaking about ombudsmen, I have a plethora of them in the studio this morning. It's going to be a busy morning because the 11th annual meeting of Canadian Legislative Ombudsmen is on in Vancouver right now. And the first ombudsman I want you to meet is the Honourable Jack Richardson, who is the Ombudsman for the Commonwealth of Australia, looks after the problems of 16 million Australians in his field with a handful of staff, about 60 people. And then, what about Quebec? What we know about Quebec and British Columbia, by and large, you could write on the back of a dime. But I have here this morning Mr. Yves Labonte, who is the Ombudsman for the province of Quebec, and we'll find out what the particular issues are in Quebec that he has to hammer with. And of course, for reinforcement, whether or not he'll answer questions about the present state of legislative confusion in British Columbia, I don't know, is Karl Friedmann, the Ombudsman for British Columbia. As you know, I have been concentrating as of necessity, because of the lack of public explanation from the government of all the nuances and implications of their sweeping legislative changes. And I have in the studio this morning a man who has been extraordinarily outspoken about the BC spirit. His name is Dubell, and he is the director of the School of Public Administration at University of Victoria. And just to whet your interest, he suspects, if he hasn't changed his mind since he wrote this little thesis, that there is an element of vengeance, vendetta, and vindictiveness in what the Bennett Social Credit government is trying to do. And maybe Dr. Dubell is testing tenure when we think of that particular legislation. Now, Hanne Jensen hasn't screamed on this program, but she's here this morning. Hanne Jensen is the one person who has been fired, wham bam, by the Social Credit government as they gutted the old Human Rights Code and replaced it with something about which we don't quite know. And one of the authors of British Columbia's Human Rights Code, now dying, is Professor Bill Black from the University of British Columbia, and he is here too. But first this morning, we don't have to say ombudsperson anymore now. The ombudsmen are first after the break. Professor Jack Richardson has been the Ombudsman for the Commonwealth of Australia for the past 6 years. What does that mean? Does that mean that you've got ombudsmen for all the states and your field is particularly restricted to federal issues?
Yes, so it goes right through Australia, Jack. There are state ombudsmen, just as you've got provincial ombudsmen in Canada, and I deal with the federal affairs.
Now, do you have any statutory rights to correct injustices on your own, or do you rely, as our ombudsmen do, on public pressure through your reports to Parliament?
Ah, we've certainly got a lot of power to correct injustices on our own. Like your ombudsman in Canada, I can only make recommendations to the government departments whom I'm criticising. But I expect them to carry out my recommendations, and that's that.
And if they don't carry out your recommendations, then what do?
I go hot foot to the Prime Minister of Australia and tell him all about it and get his support. And then you find out which ministers count and which don't count.
But then you'll find out if the Prime Minister counts too, whether or not he's willing to accept your interpretation of an injustice.
Yeah, that's right. I agree with that. I go along with that. I've had no trouble getting my Prime Minister to agree with my way of thinking.
Do you deal particularly with individual human rights?
Yes, we've got a Human Rights Commission in Australia, but the Ombudsman deals with the complaints of particular citizens, and of course they often go far beyond human rights.
But of course, if you've got provincial legislatures, that restricts your access to the individual's complaints. What can you handle?
Oh, we can handle anything that involves an actions by federal bureaucracy, you know, and there's a large federal bureaucracy in Australia, just as you've got a large one in Canada. And they're not responsible individually to members of the public, and that's where I come in. And if you had a federal ombudsman in Canada, he'd do the same sort of thing, I imagine.
Well, I know that our own ombudsman, Karl Friedmann, has had considerable difficulty in getting files from the government, from the legal departments. Have you power to get files?
I'll just have to give Karl a bit of advice how to get files. We've got very strong powers to require departments to produce files and papers, powers of a Royal Commission, actually, and they produce them, yes. I'd expect them to be produced.
Unless, of course, the Cabinet rules that it's an excluded matter to which you have no right to see.
Oh, the Cabinet can't rule that at all under our power. I've got it under the statute that I can call for any documents relating to a particular complaint.
Including Cabinet minutes?
No, there are some limitations on Cabinet minutes, but they've got to be genuine Cabinet minutes and not things that are sent up there just for the sake of escaping an Ombudsman investigation.
But you also act as an Immigration Appeal Commissioner, do you not? That's an unusual function, is it not, for an Ombudsman?
De facto, perhaps an appeals commissioner. What I do is investigate complaints from people who are part of Australia's migration program who think they've not been justly treated. In some senses, I suppose that's an appeal. Yeah, I investigate that sort of complaint.
Can you correct them?
Only make recommendations, Jack, but again, I say I want those recommendations accepted.
You have an unusual function in that you can look at the economic losses of business in relation to tariffs, is that so?
Oh, well, yes. You see, federal government in Australia, like government here, is all pervasive. It's affecting the day-to-day lives of citizens, and in economic matters as well as social matters. And when you get things like tariff cuts as a part of deliberate government policy, the consequences are enormous. And you get injustices that firms aren't adequately compensated for the loss of business as a result of government policy. Those sorts of complaints frequently come to me as Commonwealth Ombudsman.
Tell me about the telephone calls. You don't have a private telephone system in Australia. You have a federal system.
Yes, it's traditionally different in Australia. We've got a public corporation called Telecom that deals with, offers the telephone service. And if a person doesn't think he's getting a good service from Telecom or his telephone bill's too high, he can complain to me as the federal ombudsman.
You'd go crazy in this country.
I don't know, your telephone service here is not too bad. I reckon it's as good as ours, but we do get strange sorts of complaints at times.
But what about the 80-cent call you quibbled about?
Oh, this is one I was mentioning earlier to the Ombudsman conference here, that we had a lady and lived in a town called Rosedale in Victoria. And she was telephoning Melbourne, that's the capital of the state of Victoria down south, and she went to a public phone box and took a 3-minute call. It cost her 80 cents. She had to feed 4 20-cent pieces into the telephone box. And one day she was up in Melbourne and wanted to ring a friend of hers in Rosedale. So she got a public phone outside a post office, actually, and she was required to put in $1. And so she put in that $1 and thought, God, that's strange. So she went in to see a clerk behind the post office counter. To see the post office was just near the telephone box. And she got this captive clerk and said, look here, she said, how is it that it costs me only 80 cents to ring from Rosedale to Melbourne? And now they've just been charged $1 to ring from Melbourne to Rosedale. And he looked at her and he said, look, lady, he said, when you're ringing from Melbourne to Rosedale, you're telephoning uphill.
Did you get a 20 cents back for
Yeah,
it?
we got a 20 cents back and an apology from Telecom for a specious explanation.
Yves Labonte, the first question that comes to me as far as Quebec is concerned is, Quebec in years gone by wasn't noted for its civil liberties, was it?
Well, I think it was, yes.
I'm thinking of the Jehovah's Witness padlock law.
Padlock.
Eh?
Oh, yes, there were years ago. Years ago that happened, yeah.
All right,
And there weren't any ombudsmen then.
No, none whatsoever. Now, if I come to you now as a dreadful wasp of the worst order, and I scream and rant at you about the signs only in the French language, no signs in the English language, will you come to my defense?
I will try. But if my investigation proves that the civil servant has applied the law, well, I can't do anything. If there is an injustice, I mean, if somebody has acted against the law, then I can intervene. But if it's simply the application of the law, then I have nothing to say.
In other words, if the law has been properly applied, there's nothing you could do.
Nothing I can do.
You might draw attention to what you think is an injustice in your report.
Yes, I can do that.
What are the major issues you deal with as the ombudsman in Quebec?
Well, in terms of volume, I would say that the social welfare is the most important department from which we receive complaints, against which we receive complaints. And you're of course looking for sensation, I mean sensational issues, and I can understand that.
Far be it from me.
But most of the complaints that we receive are, just like Jack said a few minutes ago, 20 cents telephone call. There's an injustice, but it's a small thing. If you think of this lady whose social welfare has been discontinued, it's not very important, but it's a social. It has an importance on the social level, and if she has been unjustly refused her social welfare, then we intervene.
What about property acquisition by the government? What about arbitrary seizures or bad, what's the name of the word, expropriation cases? Can you put your nose into that?
Yes, we can. If, for instance, we figure that the amount is not sufficient of the expropriation, or if the procedure has not been followed correctly or properly, then we can intervene and make a recommendation.
Matter of instance, he's got 60 people for the Commonwealth of Australia. How many do you have for the province of Quebec?
40 people.
40 people. How many complaints last year?
12,000.
How much trouble with the government?
Trouble with the government?
How much difficulty with stubborn cabinet ministers?
Well, we don't have really difficulty with stubborn cabinet ministers. You know, we deal mostly with the civil servants, and most of our recommendations we call informal recommendations. That is, the correction that we ask the civil servant to make are followed.
To you, gentlemen, is it not a fact that if members of Parliament, members of your National Assembly, and members of our legislature and whatnot did their jobs properly, ombudsmen would not be needed?
I don't think so.
Well, I don't agree with that. The difference between an ombudsman and a member of Parliament is just this. If a member of Parliament wants to make a complaint on behalf of one of his constituents, he writes to a minister and he gets an answer back from the Under-Secretary or his Deputy Minister, and that's that. Whereas if you go to the Ombudsman's got the power to get the files and all the relevant documentation, and once you've been through those files and looked at them objectively, you may come up with a completely different answer than the Member of Parliament is likely to get from when the interested department prepares the reply that goes to the member. So I think they're complementary roles, but I think ours is really more effective because
you have more clout to get inside than they do.
Exactly. Yes.
We have the powers of a Royal Commission. You know.
You can subpoena people. Put them on oath.
Yes, sir.
Put them through.
Yep.
Seize the documents arbitrarily. Right?
We can
Not
do that.
arbitrarily.
Under your powers.
Use the powers responsibly. We're not arbitrary people.
I'm sure you wouldn't be. We're going to be joined now by Karl Friedmann, the BC's Ombudsman, after the break. Karl Friedmann is the ombudsman who certainly has made his mark in British Columbia. There have been times when he's infuriated me, but there is absolutely no doubt about his effectiveness as a catalyst to keep the government on its toes. So I'll ask you an impossible question. Would you kindly give me your considered opinion on the removal of the Human Rights Act, the eviction of the rentalsman, the amendments to the Public Service Staff Relations Act, the removal of tenure from university professors, and the ability of the government to fire public sector employees virtually at will?
You sorely tempt me to give you my opinion, but I won't. Jack, it's very simply, these are political issues and the Ombudsman can't get involved in the day-to-day politics of the province. I can give you comments on issues that come before the Ombudsman.
And none of the new stuff has come before you as an issue yet, has it?
It has, in some respects. I have received complaints that the Human Rights Act is not being enforced while it has not been repealed, and I'm dealing with that issue.
Let me get that. The director was fired, she's going to be on later on. The other people were largely paid, some are still working. What you're suggesting is that people are complaining to you that their current live complaints on human rights are not being enforced.
Well, the Minister of Labour is on record as saying that they are being enforced, and I will take him at that. And the people who have complained to me that their complaint isn't being processed properly, I have sent over a request for information from the Ministry.
Well, with all due respect, Mr. Friedman, are you not wasting time and public money, knowing that with a majority in the House, this government must eventually pass that legislation with which you will be, if the word is right, seized?
Well, I have to be concerned about the rule of law, and as long as a particular statute is in force, it is the law. When it's changed, then the new situation applies. But as long as the law is on the statute book, I think the public has a right to expect that it will be enforced.
Mm-hmm. Have you tackled many human rights cases in your past?
I have, yes, I have had a number of suggestions and recommendations I made to the Human Rights Branch. As you may know, there were a fair amount of complaints about human rights investigations taking a long time, and we've made a number of recommendations, and both to the Human Rights Branch because we thought some of their procedures could be improved, but also to the government because they didn't really give enough staff to the Human Rights Branch for them to handle the cases properly.
One particular local question, if our guests will forgive me. Has your budget been cut much?
It has not been cut more than anyone else. In fact, I believe I have had the lowest cut of all budgets.
Now, as you go into your conference now, are there any general problems from British Columbia which you're raising to your guests from overseas and the legislative ombudsman in British Columbia, such as?
Well, all the Canadian provincial ombudsmen, for example, are going on record in this conference that we desperately need a federal ombudsman. We're handling...
Don't we have one?
No, we don't.
What have we got?
We've got a number of specialized ombudsmen who do special investigations like penitentiary, official languages, privacy, and information commissioner. That we got, but we haven't got anyone.
What about Fairweather? What's Fairweather?
Well, that's human rights. You know, that's where a private citizen has a complaint against another private citizen. But what I'm talking about is when you have a complaint about Veterans Administration, Indian Affairs, taxation, those sorts of issues. And we get far too many in the provincial offices, and we have to carry, and the provincial taxpayer has to carry the cost. Now, I must say immediately that I don't spend a lot of time on it, but still, the public expects that I'll give them some answer, some assistance, and that takes time. And we've had promises from the federal government since 1977. It was twice in the throne speech. There was a bill, and we still haven't got a federal ombudsman.
So that for you, Yves Labonte, are you with Karl in the spirit that the federal government is failing in its duty by not having a federal ombudsman to look after the matters which Jack Richardson would look after?
I think that we should have a federal ombudsman, of course, provided that this wouldn't give the federal the opportunity to impeach upon the jurisdiction of the provinces.
I knew you were going to say that right away. But if it was unemployment insurance or Veterans Affairs or...
Sure. Well, there are joint programs, shared programs, and there might be problems there. But still, I think there is a necessity for federal ombudsman because we have many complaints against the federal government, and we can't do a thing. And just like Karl just said, we have to deal with these problems. We have to meet the people and tell them what they should do. But we have no power to investigate. We lose time.
Is an ombudsman a mark of a civilization and sophistication of a country, or is it a mark of freedom?
It's a mark of freedom. It's the mark that people want accountability of public servants who are there at taxpayer expense, that they do their jobs properly and they don't arbitrarily interfere with the rights of citizens. And as long as you don't have a federal ombudsman, you're only dealing with half government. And often federal governments are dealing with matters which affect the day-to-day lives of members of the public, social security, immigration, veterans affairs, this kind of thing. And in Australia we now have this complete cover, umbrella cover, with state and Commonwealth ombudsmen. Of course you haven't got that, as Yves said, in Canada.
Mm-hmm. But
I would like to add to that, to answer your question, I feel that the ombudsman is an essential mechanism in a democracy, because the civil service has too much power and anonymity. Somebody has to protect the little guy against the powers of the bureaucracy.
tell me, go on.
I was going to say it's absolutely essential because the ombudsman has the power to go inside the civil service. He's got access to people, to files, until he's satisfied he's got all the information he needs, and then he forms a judgment. Was the civil service fair or not? Do we need changes in the procedures or practices? And I think no one in the system presently does that. If our legislators had greater powers, had more committees to investigate that sort of thing, they might be able to do a part of that job too.
Are we winning or losing?
On what?
On ombudsman and freedom.
I would think the public would get mighty upset if there was no ombudsman service, you know, especially those who have had the experience of dealing with it. And there are many people who think they'll never need an ombudsman. But when they get that complaint, and I've got a number of business complaints. It's not just a little guy on social welfare cases, you know. I've had complaints from business, for example, about ICBC's appointment procedures. They said, oh, well, we can't have another agent in this city, okay? And they give them 2 days' notice to appeal. They don't tell them that you can appeal. From workers' compensation, I've had complaints about assessments, you know. You're dealing with businesses.
He's dealing with a very interesting case just now. He probably can't talk about it, but he's gone to the Supreme Court of Canada, or somebody has.
Yes.
About his right to question the decision-making behind the closed doors of the government. That's the issue, isn't it?
Yes. I can talk about the issue that's before the court, in the sense just explaining what it is, you know.
Look, we know, we're familiar with this thing in Australia. We're watching Karl's performance in the courts, because you get a decision in a court, even in Canada, it affects ombudsmen elsewhere. These cases tend to be used as
They become precedents.
Yes.
And we in Quebec, we intervene in that case.
On his side?
On his side, yeah.
Gentlemen, I wish you well in your 11th annual conference. I'm sure that you're all secure in your jobs because of the public acceptability, but you never know what government's going to be in power tomorrow. My thanks to Yves Labonte, the Ombudsman for Quebec, Professor Jack Richardson for the Commonwealth of Australia. Did I say it right?
Pretty close, Jack.
And Karl Friedmann of British Columbia. Thanks, gentlemen. Next, Rod Dubell, Director of the School of Public Administration at the University of Victoria. After the break. I've had on my desk for a couple of days a paper entitled What's the BC Spirit? The Recent Experience in the Management of Restraint. Now, for those of you who endorse wholeheartedly every aspect of what appeared to be the social credit plan for British Columbia, I would just like to remind you that it is essential that criticisms of the legislation or criticisms or interpretation of the legislation must be brought forth now, because you can't make a decision about what's going on unless you hear all kinds of views. You will be hearing, Premier Bennett has been invited to appear in this program, and I trust and I know that in his own good time, when he has a moment, that he will appear in the program. And we are and shall be continuing to interview social credit cabinet ministers as we can get them to come and explain their particular legislation. So don't snipe at me for being on an analytical, critical bent these days. And when I saw Rod Dubell's paper, and he runs the School of Public Administration at UVic. Is that the only School of Public Administration in British Columbia?
In British Columbia, yes.
And your function in that school is what? To examine how public administration is handled?
Yes, the practice of public administration, the background, the disciplines which go into management in public administration.
Perhaps was it unfair of me to pick out a simple solitary catchphrase that there was an element of vengeance, vendetta and vindictiveness, which you mentioned in your analysis of the Bennett Plan?
Well, it's not unfair. The line is in the paper, but I guess I would argue that it's a subordinate element of the paper. It's a throwaway line, really, to observe that it is hard to escape the feeling that some of this program is inspired by a motive of getting back at people who were opposing the government in the election process.
Yeah, but what intrigued me most of all was coming up to your peroration when you talked about the fact that the vision is to be British Columbia turned into a lean machine ripe for foreign investment. Would you care to develop that little theme?
Well, I guess the government has a serious problem with the economy, and one of the problems is the lack of investment activity, lack of capital formation. Mr. Bennett's vision, it seems to me, is an important aspect of a policy to try and solve some of those economic problems. My case, I suppose, or my claim, is that the strategy that was adopted in this program is the wrong way to go about creating a climate that is good for capital formation. It's even perhaps the wrong way to go about attracting foreign investment. The notion that you can create a climate that's hospitable to foreign investment by confrontation with the labor unions, by really using the authority of the government in a classic confrontational way.
By fiat.
By fear, basically, yeah.
By fear and fiat.
Exactly. That notion may just be wrong. It may turn out that creates enough trouble that it scares off foreign investors rather than encouraging them.
In other words,
no doubt you have to have a better labor relations climate, but whether you can get it by confrontation, I think, is the real issue. Right? Whether the strategy that was adopted here is right, I think, is the question I'm raising.
Well, you are obviously accepting the fact that the program as it is now could lead to a stalemate and a climate of confrontation.
Yep, and I think the real problem is, well, I think we're there. I think we have stalemate and we have confrontation, and the question is, how can you move now to get out of that situation? How can you get people talking again and in a reasonable way in which they have some respect for each other's positions and each other's motives?
Do you suggest that this is the deliberate softening up of the unions to create?
That's my reading of what they're attempting to do at the moment.
And in softening up the labor unions, what might that do?
Well, my concern is that will create a climate in which you have very little progress, very little move towards greater productivity, very little hope of implementing change that will streamline industrial processes.
But wouldn't it bring a more docile labor force if it's all successful?
The interesting question is whether, in fact, it won't create a coalition that blocks everything the government is trying to do. The coalition is big enough to block. I don't think it's a majority. I think if you took a referendum on the government's program, the majority would still support the government in what it is attempting to do. But the coalition that's been formed in opposition to that program is big enough to block almost any forward movement that the government may attempt to promote.
Only if it goes on civil disobedience of some kind.
Well, or no, I think it's more active than that. You need much more active cooperation to implement the kinds of changes you need to improve productivity, to create a more competitive environment.
What
in the
about
economy.
the removal of all these administrative tribunals, which up to now have been regarded as those for education, conciliation, and mediation? Could you say that you're fearful of the destruction, the dismantling of much of the apparatus of true collective bargaining?
No. Yep.
Right?
I think, yep. I am.
Well, let me give you a very hard-nosed question. Bennett's aims and objectives appear to be desirable and in the right direction in this particular economic climate, correct?
The general aims, yep. The strategy, less so.
He has amended Bills 2 and 3, the Public Sector Employers Act. Do you regard that as a fair bill?
No, I don't. Neither Bill 2 nor Bill 3 seems fair as drafted. And I suppose in both cases I would claim those are the kinds of measures which require some consultation, require to bring along the people involved, require to achieve acceptance before you try and lay it into...
But to get his freedom to trim and slim without the hindrance of seniority or negotiation, did he not have to remove job tenure from all public sector employees?
Well, I think that's where you have the debate. I don't think in the end that you needed to take a hatchet of that size to achieve the goal of downsizing and the goal of slimming and trimming. I think that in the end, I think it has to be accomplished in some kind of a consultative and cooperative way.
I want to ask Professor Dubell, Rod Dubell, University of Victoria School of Public Administration, more on the sensitive topic after the break. Rod Dubell, University of Victoria. Do you concede that Bennett had to take tough steps to bring public expenditures back into manageable basis on his budget?
Yep, I think the government had a real problem when it came back into office. And
how would you suggest he could have handled the cutting of the civil service without, as you say, interfering with the true apparatus of collective bargaining, or the apparatus of true collective bargaining? How could he have done it?
Well, fundamentally, I think he could have done it by dealing with the BCG EU in this case, dealing more openly or more cooperatively with the labor movement.
Are you suggesting that what he should have said was, okay, gentlemen, when the contract ends on October 31st, these are going to be the terms of reference, and if you don't like it, strike?
Well, I think some of these things could have been negotiated. Whether, again, there's a good basis for argument or difference of opinion on the question whether you could have expected to negotiate more strongly, more effectively in the normal setting, or whether you had to do something to get the attention of the union ahead of time.
What you're saying is that sitting down with the union and saying to them, this is an impossible task we have, would require your cooperation in, say, shifting and the hours which will be worked under the contract, not the hours of work, but how you work your hours, that they might have said, okay, we'll go along with that for a period anyway.
I think you could have gone some way down that road. They have indicated that they're willing to work on these issues. I think the writing's on the wall for the government's union as well as for a lot of other unions, that the style has to change, the ground rules probably are changing, and there are going to have to be worked out some considerable concessions.
Now, but you're suggesting the unions weren't given a chance to show how cooperative they might have been.
I think that's right. And how cooperative they might have been in the new circumstances, recognizing that the government had been re-elected, recognizing that there were going to have to be some considerable changes made. I think they could have done that in a consultative way. A body, in fact, did exist, this Joint Committee on Productivity, which union and management were looking at issues of downsizing and redeployment. That might have been taken further than it was. Mind you, the union in some sense invited the response they got because they dropped out of that joint committee on their own as a result of the BCG EU convention in June. Perhaps now they would wish that they had not done that committee would have been the obvious vehicle to use for the purposes.
But is it not a fact that this action at least has made it quite clear to everyone in the province that the government is back as boss in running its affairs, and it's going to stay as boss, and the message has also gone out to the public sector unions, right?
Right, and I think that's exactly the purpose, and I think that's exactly where the serious question arises. Can you in fact run a government with a cabinet as boss? And is it possible to run the cabinet, run the province in the image of a small corporation in which there is a boss who does things by authority, where the hierarchy is respected? Or do you have to run a parliamentary government in a process of consultation, bringing people along, achieving some acceptance, bringing the various interest groups together, letting them work out their differences, not on the basis of authority, but on the basis of some other kind of shared...
And you're suggesting this is a case where our parliamentary democracy is kind of being ignored to a point?
I think it's a failure to appreciate that consultation and reconciliation aren't an interference in effective management. When you're talking about a parliamentary democracy, that's what you're talking about, is a process of reconciliation and consultation and conflict resolution. That's not getting in the way of good management or strong management.
Yeah.
That is good management.
But are you not concerned as you line out in this very sharp speech? Oh, by the way, what do you think of the Fraser Institute?
Very perceptive analysts on somewhat of an extreme end of the possible spectrum of opinion, I guess.
You mean the very right wing?
Very right wing, yes. You know, carrying the logic of the free market to its logical conclusion.
And you don't believe that apologia about ability to pay, do you?
No, not in a setting where you're trying to do things by authority. I think you need some discipline of that kind on the public sector expenditures. Ability to pay, it seems to me, is the best thing that I can think of in a situation where people are working out the ground rules cooperatively. But it's not a strong enough concept to take the weight of trying to do things by authority.
Yeah, but is there not through this, and I'm going back to your speech again, is there not through this, what's the word to say, a kind of philosophy which apparently concerns you? Let me just quote to you. Destruction of machinery for enforcing human rights legislation. Removal of administrative tribunals to protect consumers, tenants and others. The emasculation of the legislature through government by regulation. The demonstrated precedent that any public servant or appointed official serves at pleasure, as long as the cabinet desires are not questioned. Are you really fearful of what political philosophy you can see in this government?
I'm fearful of the consequences of the restraint program. I'm not sure that it's altogether political philosophy as it is management philosophy.
Do you think they're naive?
That's in some sense what...
Do you think Mr. Bennett and his advisors in his cabinet, from whom he presumably has a consensus, are naive?
I really think that they are not appreciating the nature of management in the context of parliamentary government. That's why, in some sense, I spoke out on an issue which fundamentally I think is not a job for someone teaching public administration to do, is to take a partisan political position. On this issue, I'm speaking out really because I think there's a management question and a philosophical question as how responsible government is carried out.
So you're not taking a partisan position. You're looking at it clinically and analytically and saying, here's a government which is not using the parliamentary consultative process with its employers or with the public as it should do.
Mm-hmm. Yeah, fundamentally, the paper is supposed to be analytical. Language is a little bit more colorful than it perhaps should be, but the concern is not really a partisan concern, I think. It's a
concern
with social process and responsible government.
One last question, Chief. I've always attacked tenure, you know, just in general principle, because I'm a provocateur. I'm against the government, any bleeding government. I'm against the government. I don't care who it is. And I won't endorse the program's holus bolus because that's not my job. Are you threatened or concerned by this overall power to fire at will in universities? Do you have tenure?
I have tenure. I had tenure. You may be right that I'm testing the limits of tenure right now. Fundamentally, I don't argue for tenure as a matter of job security. I think I do agree with the notion as a matter of freedom to speak out. I'm not really worried about the consequences in university so much as I am, in fact, the consequences in the public service. And I did think a little bit about this issue because I've got some colleagues to whom I have some responsibilities and a family to whom I have responsibilities. I don't have any fear that the power to dismiss is going to be used in a vindictive way within the universities, but I have some real concerns about how the public service works when people within the public service are fearful about their jobs. Mm-hmm. That, it seems to me, is a major concern, and it's one I allude to in the paper.
Right now, so therefore you're hopeful of a consultation process between maybe the opposition. You can't expect them to consult, can you?
I think you could. In fact, I think in some sense, if this process is going to work, they got a responsibility. And that's why it may be hard to get things going again, because both the labor movement and the opposition are going to have to be cooperative participants in this process if it's going to work.
My thanks to Rod Dubell, Department of Public, the School of Public Administration, University of Victoria, for a provocative, reasoned and fascinated look at the BC spirit in the recent experience in the management of restraint. My thanks to you. Next, the one person who was fired by the BC government and the man who was deeply involved in writing the original Human Rights Code, after the break.
People don't understand that there is nobody to take care of human rights violations. There is a law in this province that stands on the books today, and there's nobody to make sure that that law is enforced.
Without being particularly snarky or nasty, a lot of people watching this are probably sick and tired of human rights, and particularly sick and tired of Hanne Jensen. Not her fault, perhaps, but her speeches during the crisis have been used endlessly and with repetition all the time. But I have here Hanne Jensen, the one person fired very quickly under the Social Credit legislative program. She was the director of the Human Rights Commission, correct?
I was the director of the Human Rights Code.
Human Rights Code.
Right.
And Bill Black, University of British Columbia, what part did you play in writing the original Human Rights Code, which we've had for a number of years now?
My students and actually Jim Mackin, who I understand was you were talking about yesterday, worked together to come up with a draft code, and we submitted that to the government, and the government adopted big parts of it in putting in the code in 1973.
Well, let's first of all talk about the Human Rights Commission. You had a very bad image, did you not?
I believe the image was a bit tarnished as a result of one particular case that the media picked on, and I think we're talking about the pierogi restaurant. Is that what you're referring to?
Well, no. Your general bad image was that there were complaints that your investigations took too long, that you handled too many trivial things, and that you seemed to be on a kind of, my interpretation, a partisan political kick at all times, causing trouble for trouble's sake.
Okay, maybe I can address those three separate
Yes,
charges.
please.
The question of delays, yes, there were delays, but that's unavoidable when you're not given the resources to do a proper job. The Ombudsman had concluded many times that the reason for delays was an inadequate level of staffing. And that was an argument that I tried to carry forward with senior ministry officials, and it never did wash. I never was provided with the resources to do the job. The question of trivial cases, I have only heard reference to 2 specific cases as trivial. Out of 10,000 inquiries that come in the door every year, that's not bad. Furthermore, that particular case that dealt with pierogies was not my decision to bring to a hearing. If anyone should lose their jobs over that, it should be the former Minister of Labour, Jack Heinrich. He's the one who wanted it to go to a hearing.
But you must have accepted that particularly funny case early on and pushed it and pushed it and pushed it.
No, it was taken in by my predecessor, Nola Landucci. I inherited it.
Yeah, I know, but much work was done on it long before it went to the minister for a hearing to be sought.
Not by me, and all of that work was concluded in May of 1981.
No, but that was done by the Human Rights Commission. I mean, I would say that was a question of somebody's bad judgment to go for the hunky bill case.
Right, and if there is bad judgment, of course, that's a matter of disciplinary action of some sort or another, and you know what happened to the former director. But no one ever raised that issue with me in-house, that there were too many trivial cases going through the system. That's what a director is for, to ensure that limited resources are only spent on the really relevant human rights issues.
Did you never once get any criticism from your minister, who was Heinrich, that you were pushing far too many trivial cases without substance?
No, not from Heinrich. I understood, although I never heard directly from Mr. McClelland, that there were certain issues he would prefer that I not address. And my response at the time was, as long as the Human Rights Code requires the director to accept complaints of discrimination, I intend to continue doing that until I'm instructed in writing to stay away from certain areas that are considered too controversial. And I think that is the proper function of a public servant.
Well, there are no areas which are too controversial. It's a question of judgment of what's trivial, isn't it?
I agree that it is a question of judgment of what is trivial.
I mean, I'm sure, and I say this without any backing at all, but I'm reflecting a public perception.
Yeah.
The public perception being that there were some cases that looked like they were set up for people to be nailed under the Human Rights Code. Is that not correct? Some of them looked like that.
I agree that that's how it came across to the public.
Some of the nightclub cases, it looked to me like this was an effort to, I'm not saying it was, but that was the public perception, that it was a setup.
Yeah, and I think we are in fact focusing on the one issue that is of concern to me. It is true that public perception may be that the agency is wasting time and resources on frivolous matters, but to the minority groups who rely on human rights protection, it is not trivial and frivolous at all. And it's a question of which values will prevail in a democratic society.
Okay, now Hanne Jensen, you were fired.
Yes.
How much were you paid in the job? What was
I
your
was
salary?
paid approximately $3,900 per month.
That's 48,000 a year, roughly speaking.
Uh-huh.
Okay. How long had you worked for the provincial government?
9 years.
Always in that branch?
Always in the human rights branch.
Always in the human rights
Yes.
branch. Do you get a pension?
I don't believe I will get a pension. I am time short of the 10 years it takes for your pension to vest. So I don't believe I will have a pension.
Have you made a settlement with the government yet?
Not yet. I'm hoping there will be one.
Are you suing them?
I will sue if there's no settlement forthcoming.
Are you discussing a settlement at the moment?
My lawyer is.
And you were the only person actually fired?
That's correct.
Can you tell me how many people are still working? The Ombudsman was telling me this morning he's getting complaints of matters not being attended to, even though some workers are still in the branch.
Approximately 10 staff members are not terminated and are on the job. Mostly administrative support staff, and only one person who is knowledgeable about human rights law, and that is the acting director. Her name is April Katz. She was away on holidays during the month of July, and when she came back, she was asked to become the acting director. But obviously, she does not have the resources to move any files anywhere.
How many were in that particular branch which was affected by the terminations?
31 staff members as of July the 7th.
So
And
there are 10 still on the job?
Yes.
And 20, we'll say,
Right.
sitting at home getting paid?
That's right, until October 31. Now, if delays were a problem in the past, paying people to sit at home and do nothing doesn't at all speed up the turnaround time of complaints.
But the legislation will be passed, you and I know that.
I'm told that the government is determined that it be passed in spite of all of the protests and the concern that has
Do
been
you
expressed.
suspect that these people were told to leave because the government didn't trust them and files might have been removed?
I have never been told why they were fired. I had nothing to do with the
Were
decision.
you told why you were fired?
It was suggested to me that asking the minister to ensure that those fired people be reinstated in order that the work of enforcing the code that was still in effect be done, that was the triggering event. That's why I believe I was fired. I insisted that quite apart from Bill 27, which the government of course has the right to introduce and pass if it sees fit, of course they have the right to do that, but as a public servant my responsibility was to the legislation that's in effect today but is not being enforced now.
Hanne Jensen. I'm now going to turn to Hanne Jensen and Bill Black to get a clinical interpretation of the difference between the present Human Rights Act and the one which is coming in, if all the social credit plans go as they envisage it, after the break. When Bob McClelland, the Minister of Labour, also responsible for human rights, appears in this programme Thursday of this week, he will undoubtedly attempt to convince me that the new legislation, the human rights new legislation, is better and stronger than the present legislation. I, at this particular moment, don't quite know. I'll be dealing with him, of course, on matters other than human rights. Labour Code amendments, hopefully, and Bills 2 and 3. But here is Bill Black. Is the new Human Rights Act stronger or weaker?
Much weaker. If it weren't, every other human rights organization across the country that spoke out on it wouldn't have been complaining.
What's wrong with the new? What is it? What has been taken out of the old Human Rights Act? What's been put into the new one that you don't like and which affects, you would say, our human rights?
If I could summarize, in some cases you'll no longer be covered at all. If you were covered, there'd be nobody to do the investigation or enforcement. If somehow you got through that stage and you got to a hearing, you would no longer get any help at a hearing, so you'd have to pay the full shot for a hearing. And finally, if you got through all those stages, in many cases the damages you got wouldn't be worth the effort.
Give me that again. In some cases you're not covered.
In some cases you're not covered, right.
There's no staff to help you prepare it.
Right.
If you go to a hearing, you go to that hearing without any help.
Right.
And that hearing could be in front of this new council.
Well, I think it'd be in front of a tribunal that would be appointed.
Tribunal.
Right.
Or you could go to the courts.
No, you generally can't go to the courts. It's up to the minister whether to have the tribunal, and if the minister doesn't, you're out of luck.
And what was the last point?
The last one is if you somehow got through those hurdles and won, in many cases the damage the tribunal would be allowed to award wouldn't be anything at all.
There would only be damages under the new act for out of pocket.
Right. So if you were in a humiliating way turned down for entry into a restaurant or something like that, you wouldn't get anything at all.
Under the new Human Rights Code, is it your interpretation that anyone could put an ad in the paper saying, help wanted men, help wanted women, help wanted whites, or help wanted blacks?
I think in that situation, the newspaper wouldn't be violating the Human Rights Code, would be my interpretation, and the only way to get at the employer would be indirectly if somebody said I wasn't hired. But if you just read it in the newspaper, at that stage, I don't think there'd be a violation. You'd have to wait and see what happened in the hiring process.
So the section of the existing code prohibiting discriminatory advertisements is out?
Is out, not there.
What about application form for jobs?
Application forms for jobs, there is no specific provision now saying that you can't ask discriminatory questions.
Well, a lot of
tried to do their job, they'd have almost insurmountable obstacles in doing it, even if they were the best people available trying to do the best job possible.
Well, now you say no staff, but I understand the tentative budget is just about $6,000 less than your old budget.
Those were the figures I saw just after July the 7th. But presumably, if they're continuing to pay human rights officers to sit at home, it will add up. Also, the Minister of Labour has said there will be a very small staff, if any.
I have.
Yeah.
Does the minister take any particular protection they didn't have before?
The one bit of information I've gotten is that this council will be full-time, which raises interesting questions in itself, because it means they're dependent on the government for their full employment, and if they're fireable at will, that raises interesting questions in terms of independence when there's a complaint against the government, I think.
But what about the minister himself? Can he be forced to give reasons?
They can't be forced to give reasons, and the minister can't be forced to give reasons.
Is that a change?
Up until now, it's not a change with regard to the minister. Up until now, nobody below the minister could dismiss a case, so there was no occasion to give
What you're
reasons.
telling me is that this whole new act makes it much more difficult. Many aspects which are accepted across the country are not covered, that you'll get very little help in trying to make your case, generally designed to make the Human Rights Council less effective than the old commission, cut down the cost, and...
I think that's just the unavoidable conclusion.
How much of a backward step is it in your view as a civil rights lawyer?
I think it's a tremendous backward step. If they had fired all the people, that would be a tremendous backward step, even if they'd kept the old act in. It's worse that they brought in a weaker act, too.
I'd say it brings us back to the mid-60s, before the whole thing got started.
Okay, calls to Bill Black and Hanne Jensen after the break, please.
I honestly believe that there's a lot of misunderstanding of what the new act both intends and will do. And I guess you get put in a position, I get put in a position of saying, trust me. And that's a tough one for some people to take.
It's a funny climate in this province just now, isn't it? It's a strange climate. I'm just going to take the calls cold and see how your image is now, Hanne Jensen. And you too, Bill Black. Go ahead, please.
Yes, I got a puzzling problem here. Okay, Hanne, you're saying that in your division, in Human Resources...
Human Rights!
Human Rights, sorry. That we're losing them. Why can't we use the Constitution in Canada, because it's basic, it has all the rights encoded into it.
Hold on, please. Bill Black.
The reason you can't do that is because the Constitution tells the government, in some cases, it can't discriminate, but it doesn't tell private firms that they can't discriminate. And even with regard to the government, the anti-discrimination provisions don't come into effect until April 1985.
And furthermore, the province must have its own human rights code to be effective in this province as of this moment.
To be effective as of this moment, the Human Rights Code is the only thing that protects you.
Just an aside on legal aid. Are you aware of anybody challenging the cutting of legal aid or non-representation through the Federal Charter of Rights yet?
I understand that there's some things in the works that'll probably be coming out pretty quickly.
Go ahead, please.
Yes, to Professor Black and a comment to Hanne Jensen. To Professor Black, isn't it an advantage to deal with the powers of a council rather than a bureaucrat being the branch director in resolving problems? In other words, you're appealing or directing your queries to the people that make the decision. And isn't there an advantage in that? And secondly, to a comment on Hanne Jensen, she comes across as a pretty dedicated individual, but I think her position is a worker rather than an administrator, because as an administrator, she must recognize that if her employer terminates 20 employees, the worst thing that she could ask for is to have those employees rehired. I'll hang up and listen.
Explain the last one first.
Okay, that's correct. It was probably the worst thing to do at the time, and I'm sure I was expected to roll over and go along with what was going on, and I refused to do that because I took the legislation seriously, and the statutory duty on the director was to continue to accept complaints and act on them, and I couldn't do that without staff.
And what was the other point?
Insofar as the first point is concerned, the question was, isn't it better to deal with a council that can make all the decisions than with the bureaucrats? I think that's a fair question. If you keep in mind who the constituency is that relies on human rights protection, they are people who are thoroughly intimidated by bureaucrats. They are intimidated by the receptionist, who is a bureaucrat, and they are almost intimidated by anything that smacks of government. Now, it took a lot of effort on the part of human rights officers to get to the point where they were perceived in the community as someone that you could talk to. If you now have to talk to a political appointment, that makes it much harder. Never mind the fact that they can make decisions. It is true they can make decisions and quick decisions, but it's usually the decision to do nothing. And
it's also that if they're in Victoria and it's all centralized, are you really going to have a chance to talk to them is another question.
Is it going to be in Victoria?
I don't know where it's going to be.
But if it's in one city and one council.
Right, go ahead, please.
Yes, one of the things that I'm happy to say that the Section 15 of the Human Rights Code that exists now is being obliterated. I'm a great believer in British common law. We have all the rights under British common law, and I'm all in favor of it. But that Section 15 was a dastardly thing, where they could walk into your home, your business, whatever, take anything they bloody well wanted without a court order. This is not right.
And furthermore, it could make you sign a statement.
Yes.
That was bad.
I would like to respond to that. The section referred to, Section 15, is the enforcement section of the Human Rights Code. The wording is an exact duplication of what was in the old Human Rights Act of 1969. It's an exact duplication of what has been in the statutes that address employment standards issues. There's no case of any of those statutory powers ever having been abused.
But the fact is, they're there, madam. I don't care if they were there for 50 years. That's wrong.
Okay, and I think politicians at that point have the right to change that. I agree with that. But as an administrator of the Human Rights Code, I did not abuse the powers, and nor did I ever use the powers that were provided to me as director.
Let's get a philosophical opinion from the civil rights man.
I think powers of investigation are a tough problem in this kind of case. On the one hand, you do want to give the people rights. On the other hand, if you send somebody a letter and say, we're going to come by next Wednesday and check whether your fire doors are closed, they're going to be closed. It's not very effective enforcement. So I think it's a question of balancing those things. It's too bad we don't have Karl Friedmann still here to see if there are any complaints.
But at the same time, even if you seize my documents so I don't destroy them, surely in normal justice, I don't have to sign a statement if I don't well want to.
I think in this situation what they were requiring is that people provide information about what happened. I can understand how somebody could have misused those powers, to be honest.
So you're not worried about these powers being out?
What I'm worried about is that they've gone too far in the other direction, and that under the new act they'll have so few powers they won't be able to effectively investigate.
Go ahead from Victoria.
Good morning, Jack.
Morning.
Ms. Henson, number one, what's the matter with the 1960s or the 1950s or the 1940s? And secondly, on a more personal level, do we not, each and every one of us, have our own individual choice on what we want to do, how we want to do it, and whatever way we would like to put that personal feeling through without interfering with you or anybody else? What do we have to go through? Let's look at it individually, and not from the kind of clouded shroud from something upstairs.
Well, I agree with you that as individuals we do have the right to decide how we want to run our lives, and that is in fact what human rights legislation is based on. That you should be able to function in society without being impeded because of a group factor over which you have no control, such as your race or your sex or your age, and that's what the principle is. That doesn't interfere with who you want as friends and who you want to surround yourself with. As to what's wrong with the 40s or the 60s, there's nothing wrong with it. They were wonderful times, I'm sure, but this is the 80s. That's the difference.
Pat Burns on his program last night
Oh, surely you're not going to quote Burns to Webster. I'll be back after the break. See, no discrimination. I just took a call blind. Go ahead, please.
Yeah, good morning, Jack. I'd like to address this to Hanne Jensen and partly to Professor Black in regard to Hanne Jensen's statement that she's only had a couple of cases which were trivial, and I've had to deal with Hanne Jensen. There's been a vast number of cases, and she categorically stated this herself, that the Human Rights branch was just there to accept and investigate a complaint, regardless of whether or not the complainant had a genuine complaint. And this is exactly what did occur. And it went further than that. Where third parties were concerned, the third party had no course of redress to have the complaint remedied. In other words, if say the two parties or one party made a complaint about another party, then there was a third party concerned. The third party had to go to court and go to a lot of expense themselves in order to get redress. Now, and this, as far as the Human Rights Code is concerned, this made the Human Rights Code a very narrow type of code. I can't see how you can sit there and say that the new Human Rights Code is weaker than the original Human Rights Code.
Okay, I think we've got the point, have we?
Yeah,
I think so.
I don't know whether you have or not.
Yeah, what about the third party? Were third parties often...
Where a third party is concerned, if there's one party makes a complaint about another party and they refer to another party.
Okay, I've got that point. What do you make of that?
The Human Rights Investigating Officer, purely on what the other party says, makes a judgment and writes a letter. And the letter is written just purely what the person says over the phone. No way of checking it out to see...
Were many complaints made on the basis of hearsay involving third parties?
There was an extensive screening mechanism up front to ensure that only those complaints that gave reasons for the allegation appeared to be a merit were accepted for investigation and an officer assigned. That was the screening mechanism.
How many of the complaints would fall through, though? 90%?
Well, out of 10,000 inquiries a year, only 600 would result in formal complaints.
So therefore you've got 9,400 which were complaints which were not justified or worthy of detailed investigation.
Right. And furthermore, it takes an inquiry or investigation to find out whether the complaint is of merit or not. You can't prejudge that based on a phone call.
Yeah, I get your point, sir. I can see there was a hell of a lot of wasted time in that.
Well, it was usually one phone call, I think.
Go ahead, please.
Yeah, good morning. This is exactly, Mr. Jensen has just made my point, that now the code has been amended. I agree it's gone too far. However, now it has been amended. A lot of these 10,000 complaints, now the people have to pay their own nut to get a lawyer, to initiate a complaint. Now they're going to stop these frivolous complaints, stop wasting civil servants' time, and maybe now we're going to get down to those cases that are discriminatory, will be investigated quickly, and these other frivolous complaints, people are going to say, well, hey, we don't have a case. Now you got to pay a lawyer yourself. You're going to think twice about it.
Okay.
I'd like to make 2 points about that. Number one, I think if the complaint that gets turned down takes one phone call, sometimes that can be a valuable phone call, because it takes somebody who thinks they've gotten a raw deal or have been treated illegally and shows them why not. That doesn't seem to me wasted time if it's all done in one phone call. The other point about getting rid of the frivolous cases because people have to pay money, that's probably true. The trouble is that you're throwing out the baby with the bathwater because you're getting rid of the valid complaints too, where somebody's out of work and told all you have to do is pay a lawyer $5,000 and you can go ahead.
Well, granted,
there's got to be a reasonable balance in there somewhere, and you people probably went overboard with enthusiasm.
And if we did, it should have been brought to my attention as director and the one responsible for how the program was conducted, and it wasn't.
Which minister authorized the investigation into golf tee-off times?
Well, a minister does not authorize the beginning of an investigation. The branch is responsible for...
Was there a hearing on that one?
No, of course not. But someone made an allegation based on that a denial of public service was taking place based on the sex of the individual, and the code requires the director to accept that complaint. To the woman who showed up on a Sunday morning with her husband to play golf, it was not frivolous at all.
Yeah, but I'm not talking about somebody playing golf. I'm talking about livelihood.
Yeah.
I know how much...
Here. That's a frivolous complaint.
Uh-huh.
Damn right it is.
Should
I'm
not have been
talking
investigated.
about the amount of time that people in my office waste, you know, doing background work because we refuse employment to one particular person, because we know that that particular ethnic group is well renowned for running to the Human Rights Commission, where in, you know, base of fact, we say, hey, this person is not deemed suitable for employment, boom, end of issue. You know, we waste an awful lot of time doing unnecessary background work, which then, again, further down the road, it goes to those people going to the Human Rights Commission. So now, you know, there's more wasted time for nothing.
Was there any truth in that, broadly speaking?
Well, I appreciate the nuisance factor that an employer goes through when he has to come up with a justification for decisions that were made for reasons that may have been discriminatory.
But he didn't have to give you his reasons, did he?
It certainly helps when someone puts forward an argument that there was discrimination if the employer did not discriminate, for him to come forward with what they were. That's what I would do.
Can I, as an employer, just say, no, I've decided Joe Blow or Ginny X?
Well,
that's my decision of the capabilities and qualifications.
But that's the very essence of human rights legislation. Should there be some review of how decisions are made in order to ensure that all people who live in British Columbia have the equality of opportunity? Is that important or not?
That's a tricky one, Bill.
It is a tricky one, Jack, but I think when you're comparing rights, what you have to say is if some groups just can't get jobs, can't get a livelihood, maybe employers have to do a little work to try to deal with that problem.
Kelowna, go ahead, please.
Good morning to Hanne Jensen. 2 comments. First of all, I wonder what percentage of your human rights complaints originate from people who immigrate to this country and who do not accept the living standards, if you will, or the way of life of this country, but rather try to continue to live in the style that...
Okay, I've just got time for an answer to that question. I've got 30 seconds, right?
There was no test as to whether a complainant was born in Canada or was new to Canada or how they lived in their own personal homes. No.
Well, I think that's where a great deal of the public antipathy comes from.
Maybe, well, we're going to have the proof of the pudding is in the eating. If and when the legislation passes, then we'll know if it's a cop-out.
Right.
My thanks to Hanne Jensen, Bill Black. I'll be back after the break. That guy who phoned yesterday will notice I've squared off my sideburns. Tomorrow I hope to have Jim Chabot on Deputy Minister's pensions, briefly on the microwave first thing in the morning. You listening, Jimmy? I want to deal with the rentalsman's problems tomorrow. We've got to recap the whole ground. I have an NDP by Graham Lee over here on a specific mission tomorrow, a bit about foster parents in Webster, 9 a.m. precisely.